with your relationship with Stapleton again. You wrote a Delaware Law Review article. The article praised the judicial philosophy of Stapleton. You clerked for him. In your article, you described Judge Stapleton as carefully working through the Supreme Court previous decisions and opinions. The fact that he doesn't make up the law, he tries to find the law set by the Supreme Court. I'm hoping that we'll talk a little bit, as you already have done, about your judicial philosophy, and I'm wondering if you take the same approach as Judge Stapleton, or if your approach is somewhat different.
Well, thank you very much for the question, Ranking Member Grassley. I learned a great deal from Judge Stapleton, including the process that I have outlined of how I have approached things as a district court judge and how I would continue to approach things if confirmed to the Court of Appeals. It's a careful focus and a lot of diligent hard work, I should add, to understand the binding precedent, to understand the record. In trial court, of course, I'm part of making that record, but if confirmed to the Court of Appeals, my job would be to review the record that's already been made and then to apply that binding precedential law to the record before me, focused only on the issue that is presented.
I want to go to the case that you were involved in, Barks versus First Correctional Medical. In this case, Christopher Barks was being held in a correctional institution. He committed suicide while he was being held, and his estate sued. You ruled that qualified immunity did not apply because Mr. Barks had a clearly established constitutional right to adequate medical care. The Supreme Court implied that the right at issue had to be defined more narrowly. The court noted that, quote, no decision of this court even discusses suicide screening or prevention protocol, end of quote. Question. With that background, would you explain how you understood the Supreme Court's approach to determine whether a right is clearly established in a qualified immunity case?
Thank you, Senator, for the question. You've outlined the facts as I recall them as well. The case went up to the Third Circuit. The Third Circuit Court of Appeals affirmed me, I think, in a 2-to-1 decision. And as you've indicated, the Supreme Court then reversed the Third Circuit. I did my very best to understand what Supreme Court precedent was at the time on qualified immunity and to carefully apply Third Circuit precedent. The Third Circuit thought I got that right, and the Supreme Court had the right, of course, to disagree with the Third Circuit, and they did.
My last question to you would be from a George Mason Law Review article. Your article discussed how parties run primary elections. You argued that the equal protection is violated in a primary race when a political party irrationally distinguishes between its candidates. You also wrote that the state should not assist two particular parties at the expense of the other party. Could you please explain your reasoning on how party violates the constitutional equal protection of the law clause?
Well, thank you for that question, Senator. You're referring to work that I did when I was a law student and wrote an article about the topics that you have referenced. I think, if I recall correctly, and it's been 25 years since I wrote the article and sometime since I looked at it, I think it was something of a thought experiment. I had done work as an undergraduate student on the presidential nomination contest, and so I was interested in law school and understanding the legal regime behind presidential nominations, and I think I was exploring whether or not arguments could be made either for or against the constitutionality of the process.
Thank you. I yield back.
Thanks, Senator Grassley. Senator Leahy.
Thank you very much, Judge. Good to see you. I've always had an interest in the Federal Circuit, and